president of the Southern California Labor and Employment Relations Association. The hallmark of this organization has always been collegiality, and even through Zoom, I can feel, the collegiality of this group, and it's so good to be here. For those of you who are new to SoCal LERA and to LERA, this is the Southern California chapter. We were created by the combined efforts of OC LERA, LA LERA, and San Diego LERA. We always want to shout out to them. And we're offering programming to all of Southern California now. It's a special group. We're open to representatives of labor and management, union officials, attorneys, human resources personnel, neutrals, students, academics, anyone interested in industrial relations, collective bargaining, management folks, employee and union side folks, government agencies, all of us mingling and sharing our diverse viewpoints. And as I mentioned, our hallmark is collegiality. My favorite line from our good administrator, Emily Smith and Bernadette Tiemann, is that we cast light on subjects without heat, allowing us to have that sense of conversation that's so useful for all of our practices. So if you're not a member of us, this is my shout out at the beginning. Please join, renew your membership, get involved. As we exit the pandemic, we'll have more events. We have our annual labor law conference in July. We're going to send out information and updates on that. We're expecting great speakers and great materials to present to you. So again, I'll just mention special thanks to Emily Smith and Bernadette, team who got us set up today and run LERA out of the University of Illinois. Okay, first housekeeping item. Our fantastic executive director, Juan Carlos Gonzalez, will direct you in that regard. Juan Carlos, are you?
Yes. Hi, everybody. Hope everybody's doing great. Great to see everybody. For MCLE credits at the very end of the program, we'll ask you to include your email and bar number. And then once we get our certificates together, we will get them to you as soon as possible. Thank you very much. And I'll remind everybody of that at the end. Also, keep your eye on the chat for just reminders, bios, and handouts for the speakers are on our event page, and I've included a link in the chat. And I think, Josh, you're also going to take questions in the chat.
Yeah, so we're going to have questions from the audience at the end of the panel. We love questions. We want you to ask them. I think it's probably easiest if you want to ask an anonymous question, just to send it to me, or maybe that's the only way to do it. So if you send me directly a chat, you chat at me directly, as opposed to the entire group, I will read your question anonymously. If you don't mind and you don't care if the whole group sees your question, then you can chat to the whole group and I'll keep a running tally. Question and answers will be at the end, but I will, if you can post them as they occur to you and I'll collect them. Also bear in mind, we're video recording today, so you can come back and watch portions of this again if you like. All right, so welcome our panel, getting up to speed on Biden's NLRB. I'd like to do a brief introduction of the panelists. As Juan Carlos mentioned, their bios and their full bios are on the member resources section of the website. First, from the NLRB Region 32, we are so grateful to have Christy J. Kwan. Christy is regional attorney of the NLRB at its Oakland Regional Office, Region 32, as I mentioned, which has jurisdiction over portions of Northern California and the northern half of Nevada. She is the principal legal advisor to the regional director of Region 32. We're also very happy to welcome our own Thomas Lenz of Atkinson, Andelson, Lawyer, Rudd, and Romo. Tom graciously agreed to fill in today for Maria Anastas, who is unfortunately unable to join us. Tom handles all aspects of labor and employment law issues and heads up his firm's traditional labor and National Labor Relations Board practices. He works with employers in all major industries across California and the West. I am delighted to introduce to you from Kaiser Permanente, Robert Spagat. Bob is Vice President and Assistant General Counsel at Kaiser Permanente. Based in the Oakland office, Bob is the practice chair for the Labor and Employment Law Practice Group. In this role, he oversees a staff of attorneys and paralegals who advise management for Kaiser Health Plan, hospitals, and the Permanente medical groups on labor and employment matters throughout the program. And he is the principal legal advisor to Kaiser Permanente on traditional labor matters. And then also, I'm very happy to introduce Jeremy Blasey of Unite Here Local 11. Jeremy currently serves as general counsel for Local 11, a labor union for more than 32,000 hospitality workers in Southern California and Arizona, where he represents workers and the union in a variety of matters to vindicate workplace rights. Welcome to all of our panelists. It's so nice to have each of you here, and I'm excited to hear your comments. I always know I have a good panel when I want to just listen to all of you talk. To start out, so there's so much in the news and so much that's happened over the last 6 to 9 months, and I want to get initial thoughts or hot takes from panelists on the state of labor relations and what we're seeing in labor relations. I'll set the stage a bit first. So at the NLRB, the majority of board members serving there either were appointed by Biden or are viewed generally as being pro-labor or coming from labor union advocacy. We have board member and now chair as of January 2021, Lauren McFerrin. Her term ends in 2024. We have board member Gwen Wilcox, whose term started in 2021. That lasts until 2023. Board member David Pruti, I apologize if I'm mispronouncing his name, started in 2021 and goes through August 2026. And then on the Republican side of appointments, we have board member John Ring's term, which ends in December of this year, and Marvin Kaplan's term expires in 2025. So as of September 22, 2021, Democrats, quote unquote, control the board as the NLRB's own website says. We have a Democratic majority as of that date. And of course, we have General Counsel Jennifer Abruzzo, who was appointed by Biden and started on July 22, 2021. Jennifer has decades of experience working for the NLRB, but also worked for a major labor union, CWA, before her appointment. And in the last year has issued a number of GC memos, which seek change in a variety of areas. So in addition, in the private sector across the country, we have objective, significant increases in election petitions before the NLRB and union organizing generally, whether or not there's a labor union filing the petition. On April 6th this month, the NLRB issued a press release, I'm sure many of you saw, indicating that union election petitions increased 57% in the first half of fiscal year 2022, and Biden's proposed budget requests a 16% increase in funding for the agency. So having laid out some known
1-213-338-8477.
So also everyone, please put your Zoom on mute. We're getting some static from folks. Thank you.
Welcome to Zoom. Enter your meeting ID followed by.
Everyone, please put yourselves on mute. Thank you very much. All right. So having laid out some known or slightly assumed facts, I'll start out by asking our panelists what their initial thoughts are as they survey the landscape of labor relations under what I'm terming Biden's NLRB. Tom, do you want to go first?
Sure. I think that people are waking up to labor law and labor relations. I think there is a new awareness of NLRB's presence because we're hearing about certain rights being reinvigorated. We're hearing about, I think, more organizing activity, and certainly Amazon and Starbucks have been in the news. So it's been getting, front page and lead story type press, which I think is going to pique curiosity of both employees and employers. Not to mention, we're starting to see some, new groups on the horizon. So I think that coming out of the pandemic, it's an interesting situation because, particularly, with essential workers, we're seeing unions representing them that are demanding more and expecting workers to be rewarded. It's a very interesting time, and I think that we're going to see a much more invigorated labor movement.
Christy, I'll turn to you next. Same question. With the landscape as it is, what are your general thoughts on things?
Since I'm here sort of as the institutional voice of the NLRB, I guess I wanted to say that, we have a number of initiatives where we do want to make sure the law is enforced vigorously. So it's exciting to see what Thomas said, just the activity that's been going on, and there's a renewed interest. I have some new attorneys that started with us, and they're saying all of a sudden labor law is cool again. And it's something that they had never heard about. And so it's interesting to hear from a viewpoint of people born, when I was in high school, I think, to see a renewed interest. I want to say you made a comment about the budget that we had asked for, which we did not get. And so there is this institutionally, so we're seeing a lot more cases, and yet we don't have the resources and the staff that we had even 10 years ago. So there is, while it's encouraging and it's exciting time, I think in terms of the board agents, it's a very, especially in the regional offices, it's a very difficult time in terms of trying to get all the work done with the same quality, efficiently. But I'm really proud of our staff. I mean, they're doing everything they can to meet these new challenges.
Thanks, Christy. I'm so glad labor law is cool. When I told my law school professor that I wanted to go to do labor law, he said, old school. So, that's great. Bob, you next. What are your thoughts generally on things?
It didn't come to my attention that labor law was not cool. I mean, so I'm kind of glad to know that it's come around on that. We're living in interesting times. I mean, coming out of the pandemic and with all that's happened in our country, it seems to me that activism generally is on the rise among a lot of young people and a lot of people. And, it kind of coinciding with some reinvigoration through the Biden administration of the NLRB. And so people want to be involved in things. People want to start making a mark. And I think all those forces have moved towards, workplaces where there's more interest in concerted activity, more understanding of what those rights really are and what they mean. How big of a resurgence in the long run we're going to see, I think, remains to be seen. But for now, between the headlines with Amazon and Starbucks and all these forces in play, it does seem to me that we're seeing a lot more activity in this area.
Jeremy, turning to you, your thoughts.
Sure. I certainly agree with everything that's been said. This is interesting, and for those of us who work for unions, exciting time, particularly to be doing this work. Just looked up the number because I'd seen a headline about this. The approval for labor unions is now at its highest point since 1971. It's 68% of Americans now approve of labor unions, which is, kind of a remarkable number considering how few workers actually have a labor union. It's still in the private sector, just upwards of 6%, and overall, I think about 9%. So there's this sort of giant gap between those who, by surveys at least, suggest they would be interested in having a union and those who actually have one. And, I think certainly the tight labor market is, I think, empowering individual workers and perhaps workers to act collectively. I think we've also seen the sort of billionaire class acting in a way that I think a lot of young people today particularly find sort of offensive, using vast fortunes to buy tickets to go to space and the like. So the combination of all of that, I'm no sociologist, but it just seems like there's sort of a constellation of factors that are adding to this, which may not all be permanent. Perhaps the billionaire part will be, but the tight labor market likely won't be, nor, unfortunately, probably will the resurgent voice at the NLRB. So I think, as Bob said, it remains to be seen what all this will mean in the long term. But at the moment, at least, it's certainly an exciting time. I mean, the Amazon election was the largest in decades. The Starbucks organizing, as everybody's mentioned, I think caught a lot of people by surprise just by the sheer speed with which it's spread. Within our union, we're seeing a resurgence of energy amongst our members. So it's definitely a moment I think we're in, and I hope the moment lasts.
Yeah, and I'll echo all your thoughts as well. I certainly, as someone who represents labor unions, it's also been surprising to me, that we have small shops like Starbucks on the one hand, and then giant shops on the other, both of which have been impenetrable for organizing campaigns. And I can't remember a time, in my more limited experience when we've seen that happen. All right, so now turning to the panelists for a little bit deeper dive. Jeremy, do you want to start first?
Sure. So I've got about 15 minutes, is that right?
Yeah, 15 is great.
Okay, I'll try to not bore all you. I think the question that was posed to us was sort of what has caught our attention most in terms of particularly the changing legal landscape or potentially changing legal landscape for labor law. So I would say there's three things from my perspective that have been most interesting or will be most interesting to follow. And I'll talk about each of them. The first is and I'll say that none of these have actually become law. So these are all approaches that the General Counsel at the NLRB is seeking to make law, but at this point are sort of proposals. The first is the General Counsel's initiative to strengthen remedies for unfair labor practices. The second is the General Counsel's effort to bring back a doctrine called Joyce-Silk that has to do with union recognition procedures. And then finally, the third is the General Counsel's recent announcement that she's pursuing a theory that captive audience meetings, if they're at least in situations where they're mandatory and workers can be disciplined for not attending, violate the NLRA. And I think all three of those are all quite big deals, particularly the latter two. I think the first could make significant change on sort of the margins, but the latter two would be sort of sea change level changes. So I'll go through each of them and highlight some of the elements of them. So with respect to the remedies effort, I mean, this has always been something as a labor person that struck me as just sort of the degree to which remedies are weak from the sort of union perspective has always struck me as sort of a just kind of shocking. In the case of a worker who or an employer that threatens workers with job loss or interrogates a worker about her union activities or that of her coworkers or engages in surveillance, the traditional remedy has been for a long time simply a posting that goes on the wall on a bulletin board in the workplace. And that's just not a strong remedy. The posting says that the employer won't do these things again. And I don't think a lot of workers read those. So one element of the new initiative would be taking some very simple steps to, for example, instead of just posting those notices, have them read aloud to workers so they actually hear the words and the pledge of the employer not to violate worker rights going forward, to mail them out, mail those notices out to employees, in some cases to apologize to employees for committing unfair labor practices. So that's, the sort of the category of 8A1 violations, interference with the right to organize. In the case of discrimination, where an employer actually fires a worker for organizing or takes some other sort of concrete adverse action, the standard remedy has been back pay, but with deductions for any earnings the worker earned or should have earned from other employers in the interim since being terminated. And there has not been the standard remedies available for other kinds of discrimination. So punitive damages, consequential damages, and that sort of thing. And as a result, the financial consequences for violating the law are just quite meager. I would, in my experience, about 1/10 of what they would be for discrimination case, relating to age or sex discrimination and the like. And then among the new remedies would be, for example, adding consequential damages to the kinds of damages that workers can be entitled to. So for example, if a worker loses her or his health insurance and has to pay out of pocket for medical expenses as a result of being unlawfully fired, the employer would have to cover those expenses under these proposals, just as an example. And there's others that are interesting, but I'll move on in the interest of time, but we can get more into these. Among the remedies the board or the General Counsel is pursuing for organizing drives, I think the most interesting is union access rights. So if a worker's rights are violated during an organizing drive, the General Counsel is seeking to have the employer provide the union with information to contact workers, as well as opportunity to speak during meetings at the workplace where the employer is addressing workers about union organizing. And then finally, there's remedies related to the failure to bargain in good faith that are, have been applied on occasion, but would be applied more consistently, including paying for the union's bargaining expenses. So these are all things that I think would make a meaningful difference. I've had some of them applied in cases that I'm working on now, and I think they have had a meaningful difference, but they're not, in my estimation, at least, sort of game changers. They're sort of things that would help on the margins to workers who are organizing. I could be wrong about that, but that's my take. But certainly steps in the right direction from where we have been in terms of remedies. The next two really are game changers in my view if they become law. So the first of the two I'll talk about is, again, this Joyce-Silk doctrine resurrection. The Joyce-Silk, you sort of hear this a lot, but I'll explain basically what it is. The traditional remedy under existing board law for or under existing remedies, the board will only order an employer to bargain with a union absent an NLRB election showing the union had a majority in very unusual circumstances, basically only when the employer has committed such egregious violations that it would make conducting a rerun NLRB election impossible to conduct in a fair manner. And it's sort of a unicorn in labor law. I've had the experience of working on one case like that in my career, but they're highly unusual. But they weren't always unusual bargaining orders. And for several decades until this sort of regime was ended in, I think, 1969, there was, under a case called Joyce-Silk, a process whereby the board would order an employer to bargain with the union, even in the absence of an NLRB election, if the workers or the union demonstrated they had majority support for the union through a showing of cards, and the employer was not able to demonstrate that it had any good faith reason to doubt the representation that there was majority support. And that was the law for 20, 30 years with various permutations. Typically, the good faith doubt standard would be analyzed in respect to whether there was an unfair labor practice committed by the employer. So if a union presents its evidence of majority support to the employer and the employer says, no, we're not going to recognize the union despite what you're showing to us, and then the employer commits a ULP, unfair labor practice, that would be grounds for the board to find that the employer did not have a good faith basis to doubt the union's majority. And in those circumstances, under that doctrine that existed for that period of time, the employer would be obligated to bargain with the union, even though there was not an NLRB election. So what the general counsel is doing here is trying to bring back that doctrine of Joyce-Silk, and it's this doctrine is presently before the board in a case called the CEMEX Construction Materials and the Teamsters, where it's been briefed and is still going to be litigated. So it's, again, not the law, but if it was the law, it would I think very significantly improve the ability of workers to organize through non-election means. And the general counsel's argument for it, which academics and others have made, is not that this would necessarily replace NLRB elections. In fact, NLRB elections happened very frequently when the Joyce-Silk doctrine was in place, and much more frequently during that period than in the subsequent period when it was removed. But rather that it would create an incentive for employers not to commit ULPs during that election process, because the consequence of doing so could be quite grave. If there were an election, even if the union lost it, had the employer prior to the election refused to bargain with the union and then committed ULPs demonstrating a bad faith refusal to bargain, there could still be a bargaining order, as I understand it. And I can't purport to be a scholar on this, but as I understand it, that could happen. And so the general counsel's argument is this would very substantially disincentivize ULPs, even in the context of traditional elections, because of that potential outcome. And they'll point to sort of the history that there were far fewer ULPs during the era when Joyce-Silk was in place. So it's a really interesting idea. I think it would be a big, a big change in the way labor laws practiced and the way unions organize, you would see a lot more unions going to the employer and saying, hey, we've got a majority, here's the cards, come look at them, recognize us. And then if the employer commits, particularly if the employer then commits ULPs, which happen in a great number of cases, the union would then be filing a charge with the board, seeking a bargaining order, rather than going through an election. Although, again, those things could happen parallel to one another. So that, anyway, I think that's a really big deal. It could be a big change in labor law. It's not the law yet, or isn't the law again yet. The last one is the one I'm actually most excited about. And that's, as I mentioned before, an approach the general counsel to the NLRB is taking to that would bar employers from carrying out captive audience meetings, which I think probably everybody's familiar with that concept, but in case not, these are, when the employer convenes all of its employees into a meeting that's mandatory and then tells workers or makes anti-union presentations to workers. It's an interesting practice, sort of, if you think about it in the broader global landscape, because it's really an American kind of invention and practice that it's sort of unheard of in Europe and elsewhere in the world. The Human Rights Watch calls them forced listening sessions. That's the phrase they use to describe captive audience meetings and sort of get at the getting at sort of what's really going on there, this sort of coercion. And that's the NLRB's theory or the general counsel's theory that these are inherently coercive because you can't refuse to go to the captive audience meeting. If the employer tells you got to go sit through these anti-union presentations and you refuse, you could be fired. And in fact, workers have been fired, and that it's been found lawful for them to do so under the existing law. The notion is that the right to organize, to exercise your right to organize under the NLRA involves not just the positive right to organize, but also the right to refrain from organizing or refrain from hearing anti-union or union engaging in union activities. If a union were to coerce workers to attend a pro-union meeting through one means or another, that would clearly be illegal. And the idea is that if an employer does the same thing and requires workers under pain of discipline or potentially termination to attend the anti-union meeting, that's coercive too, and is an affront to this idea that workers have a right to participate or not participate in discussions about union organizing. So what the board would do here is require, if this theory that the general counsel is putting forward is adopted, it would make it so that employers would have to provide certain assurances to employees if they're going to have these captive audience meetings on paid work time. They would have to tell workers that they're free to leave, that their participation, if they do participate, is voluntary, and if they don't attend, they will not be subject to reprisals. They can't be disciplined and so forth. The same idea would apply for not just group meetings, but also cases where workers individually sort of cornered in the workplace, which happens sometimes, and given a sort of an anti-union rap by a manager. The same, assurances of voluntariness would have to apply as well. This would be a big deal. There was one study that found in 89% of cases of union organizing cases, these kinds of captive audience meetings are used by employers. And the majority of workers had gone to 5 of these meetings. I think probably folks in this call are quite familiar with how frequent this is. So, banning the practice would be a huge deal. It would really dramatically, I think, impact the way anti-union campaigns are waged by employers in a way that from the union perspective is very, very much welcome and, sort of in concert with our ideas about the freedom of choice and freedom of speech. I won't, this is certainly something that's going to be litigated, I would expect. I won't weigh into the, make prognostications about what will happen, but I have read the brief by the general counsel in the same case, the CMEX case where this is being litigated. I found it quite persuasive. There are precedents for requiring these sorts of assurances in other contexts, like where an employer is interrogating a worker in order to defend itself against unfair labor practice charge, or when it's conducting a poll. These sorts of assurances are already required, so it's not a huge leap. At least, that's the argument. So, again, I think it would be a huge deal if this were to go forward. And it will be very, very interesting to watch it play out. And in the meantime, I think employers sort of at their peril would be, continuing to engage in these sorts of anti-union tactics. Those are my three top sort of things to watch. And I'm looking forward to hearing the comments from the rest of my colleagues here.
Yeah, the Joy Silk one is so fun. I want everyone to be able to weigh in. I'll just also note, there were also there's an operational memo I think put out today on free card checks with the FMCS. And so we have the Joy Silk, which is trending towards card checks. And we also have collaboration between the agencies. Bob, I'll kick it to you for thoughts on Joy Silk or captive audience meetings, if you like.
Yeah, thanks, Josh. I guess my feeling is from an employer's point of view, in really any other context, I imagine there'd be pretty widespread agreement that the gold standard for voters expressing their free choice would be a secret ballot election. And if the touchstone really is employee free choice, in my view, that's really where the default should be. So the Joy Silk standard is, centered around the idea that a card check is sufficient unless an employer can demonstrate a good faith doubt. And, that puts an employer in a position of needing to go out and get the information, having to be really careful that they're not going to commit an unfair labor practice as they try and get that information, and being under time constraints. I think that in the net, while it certainly, I think, probably will result in more successful union organizing campaigns, I don't know that it really truly reflects employee free choice. If the issue is employers being abusive and committing unfair labor practices, then it would seem to me that some of the other initiatives that the General Counsel is pursuing to kind of amp up negative consequences for employers who do commit unfair labor practices would make more sense. So that's kind of my kind of overarching sense on Joy Silk. I guess I'll cede the floor to whoever else
Christy,
wants to weigh in on that.
Sorry, I didn't mean to cut you off, Bob. Was there anything else?
Oh, that's it. That's it.
Christy, do you want to weigh in? Can you weigh in? You may not be able to weigh in.
I'm trying to carefully think about how I can weigh in. I think, like Jeremy said, it was a position, it was that the board had, and then, we then only had Gissel cases for a while, and that was a tough standard. I would say I've only seen a few in my career at the NLRB, and it's a 20+ year career. We had a lot of investigation, we have trials, but it's very difficult to get, although there's one out of Region 28 recently, I think the casino case. So I do agree with Jeremy, it would be a game changer. I wanted to kind of place it in the overall scheme of the General Counsel's view on things. There's another memo on 10J and organizing, and it's just reiterating that even if there's just threats, not a discharge, but even if just there's threats, we're willing to go 10J and seek an injunctive order. And in the past, during organizing campaigns, we first made a push under previous General Counsels to, get injunctions when there's discharges. So I think it's just moving all toward it's moving toward making it having a situation where employees, if they are threatened if they are, if there is a ULP committed, that there are real consequences. Because for a long time, like Jeremy said, we put a notice up, but once that bell is rung, you can't unring it. And so if an employee is chilled from engaging in union activity, how do you really put that back together? So I think, along with the remedies that Jeremy just was talking about, Joyce Silk, this captive audience, this new approach to captive audience meetings, I think it's all together there's a cohesion to it.
Christy, let me ask you another unfair question, and with reference to what Bob said about the secret ballot election being the gold standard, which I think has some real teeth to it as an argument. What do you think the odds are, and maybe that's the wrong way of phrasing it, that if Joyce Silk does get approved by the board, is the US Supreme Court going to look at that and under a Chevron deference standard, is what happens to Chevron deference when you have, a gold standard, right? And then you have an agency which is pushing away from that gold standard.
Well, I'm not going to be making that argument to the Supreme Court, and we have much smarter people in headquarters who are going to speak to that. But I would think that it's not in conflict, but with our goal of having secret ballot elections. I don't see I see it parallel. I don't think it's in conflict personally.
Fair enough. Tom, final word on Joyce Silk and anything else that
Yeah, I think Jeremy raised some interesting points. Regarding Joyce Silk, I think employers need to be mindful. I'm advising a lot of employers, when we're dealing with labor law and the switch between administrations every 4 years, are you going to follow the law as it is, or are you going to follow the law as it's going to develop? Because, what you're doing right now may not be considered lawful by the current board if they're going to enforce a different legal standard. It's a real rub for employers dealing with these issues and trying to be forward thinking. I expect this general counsel is going to litigate the heck out of things. And while the board has touted its rate of settlement over the years, the agenda that we're seeing and in the various memos that have been provided to our audience, they reflect, I think, some theories that some employers with resources will bristle against, and they will choose to fight. There's a lot of legal authority out there about the importance of the secret ballot election and the importance of majority support. As a former board agent, I had people come to me when I was officer of the day and say, I signed this card to get a t-shirt. It wasn't because they supported the union. And that's not to disparage any union or to say that, what they're doing is inappropriate in soliciting cards. But the fact is, I'm not sure that authorization cards are a valid measure of majority support. And I don't believe that the law necessarily blesses that. The board certainly does deserve a degree of deference, but Gissel was a Supreme Court ruling. And the board doesn't have a great result or record before the Supreme Court in the last few years. So I expect a lot of things to be litigated, a lot of employers without resources to probably have to knuckle under. And the bigger employers that are facing these issues are going to be the ones that make the difference in terms of where these rules go.
Can I comment on something that you just said, Tom, about, if someone is told something about the union authorization card and they're signing it not because they want the union or they wish to have a union represent them, but they're doing it for other reasons. I mean, if a Joyce Silk remedy is coming to us in the way a Gissel might come to us, not as a card check, but let's say we're looking at the cards, I know I could imagine that we would investigate in the same way that we investigate Gissels. And what we do is we talk to each of the, signers. We ask them, what were you told? If there's any kind of indication that they were told something else that, than what was on the card. And so from an institutional point of view, because we also really, think it's really important that employees are not coerced into signing even a pro-union card, I think we would make it a point to make sure that that's not happening and not count that card. So in the best investigations I've had, we don't count that card. you know, that the party will come to us and say, hey, we have 20 cards, and we'll look at them, we'll investigate, maybe we'll knock out 5 of them because it just doesn't meet our standard.
I think it ultimately means a process that is more painstaking than a secret ballot election, even though in theory it's more efficient. So you know, query, you know, where the value is, and you know, whether it's better just to have a vote. You know, we had similar devices in the construction industry where I litigated up to the DC Circuit, and we ended up with a new board regulation on majority representation in the construction industry. I think that you know, the secret ballot election is really important, and you know, making sure that proof of majority support is truly valid and handled under, you know, laboratory conditions or whatever you want to call it. That's really important. I think that many employers are going to fight for that.
All right, I can tell, you know, it's going to be litigated when it's this much fun to talk about, right? All right, we'll do our next deep dive with Bob. Please go ahead.
Yeah, so I was focused on the general counsel's memo on settling cases. And are we going to be talking about the protected concerted activity? Is that still to come?
You can jump into that if you want. Maria had been spearheading that, but we have our good sub Tom. So if you want to touch on that, that would be great, Bob, if it's in your interest and you have time.
Yeah. Yeah. So right. So I think part of the well, so it was a general counsel memo from Peter Orr, but that I think is now you know, kind of part of the implementation program on kind of emphasizing and defining, you know, concerted activities for the purpose of mutual aid and protection. And the idea is that mutual aid and protection is really the goal. So you're taking concerted activity, which means you know, you're engaging with other employees and you're doing it for the purpose of mutual aid and protection. So where are the boundaries around that? And in the easy cases, you know, employees are talking about wages and hours and, you know, working conditions and trying to improve their relationship. I think where the battle lines have been drawn a little bit is around things like political and social justice activity. And, you know, when does that count as activity for mutual aid and protection when employees are talking about, you know, racial equity and other types of issues. And in the general counsel memo, it talks about when there's a direct nexus to employees' interests as employees, which I would submit is, you know, a little bit vague and therefore is going to end up, you know, putting people in a gray area and you know, fostering some amount of litigation. I think right now, employee activity regarding social issues is going to get reviewed by advice. You know, if there's an allegation that employees suffered a negative adverse employment action because of positions on social justice activities. And in that regard, I think the memo kind of goes on to talk about racial discrimination being the kind of issue that might be inherently concerted under the inherently concerted line of cases. And so all well and good, but I think that it creates some quandaries for employers. And it complicates issues, for example, for employers who want to actually make steps in equity, inclusion, and diversity initiatives within their own company and try and kind of move the dial, be responsive to what's going on in the world. And when you do that as an employer, you're kind of trying to walk a fine line where, you know, you want to encourage discussion, you want to encourage people to share views, we want to, you know, kind of learn and grow and be more inclusive. And when you have those discussions, you know, some of the risk at least, what the lawyers are going to tell the company is, that you have some risks there that as people share issues, it can create conflict in the work environment. Employers may have to deal with that conflict. It may create evidence of problems in the work environment that could be used against an employer in litigation. If the NLRB is now going to be kind of weighing in when employees are talking about racial equity and what that means, and it's maybe a little bit gray as to, well, is this for mutual aid and protection? Are they talking about the workplace? Are they talking about what's happening outside when they leave the workplace? It kind of adds a degree of difficulty to the employer's considerations in trying to navigate, how do you advance these initiatives? If you've got employees who want to wear a Black Lives Matter button, but now another employee wants to wear a Blue Lives Matter button, and how are you going to reconcile that? And is all that mutual, is all that concerted activity that's protected, and how do you manage those issues? So on that, and the perception that the board is looking for ways to expand our jurisdiction into that area of the law, I think it also creates potential issues for employers who have to worry about litigating cases around discrimination and retaliation. And so if you have cases where somebody is disciplined or discharged and they're claiming discrimination or retaliation due to a protected category, if the board is also going to step in and say, well, this employee was advocating in a way that triggered NLRA protection, then you have the risk of two-track litigation, which can be pretty nuanced and complicated for an employer to manage. You've got a civil action going on the one hand, and on the other hand, you've got an NLRB investigation and affidavits being taken, and the risk of litigation over what could be very similar conduct. And so I think that as this area evolves, and if the NLRB starts asserting more jurisdiction on a widened view of what constitutes mutual aid and protection, that gets into these areas of social justice warriors, and that it's going to create some real complexity and kind of hard-fought litigation on multiple fronts. Let me also address the GC memo that came out, I think, earlier this year, advocating for full remedies and settlement agreements. And the principle is that settlements should reflect full relief for victims of unfair labor practices. So far, so good. There's a couple quotes in that memo that I think are a little jarring if you're reading it from an employer's perspective. The first one is, it says, for example, settlement agreements that provide complete relief to charging parties and victims of unfair labor practices, as well as that offer charged parties quick resolution of legal actions that reduce litigation expenditures, are highly beneficial for all. So the general counsel seems to be advancing a position that that the terms of a settlement should really be absolutely the most that you could get in litigation, and employers should be happy to breach those settlement agreements because then they won't have to go through the trouble of litigating the case. And I think that's a little bit like telling a tennis player, look, we'd like you to forfeit the match. It's going to be good for the other guy. He's going to win. It's going to be good for you because you don't have to go to the trouble of playing out a match. That must be really exhausting for you. And, it's not gonna seem very enticing to an employer to say, well, the settlement offer is, you give full and complete relief, and you're just going to avoid the litigation because I think that employers are generally, I think, well, maybe I'm going to win this case. I mean, just because the region decided to issue a complaint doesn't mean I've been found guilty. It means I have to go to trial. And so I think that, I think that the settlement memo, here's another quote that I think illustrates the problem. And this is also from the memo, because regions are less constrained by the remedies that they may seek in settlement, as opposed to those they may currently seek from the board. Regions should skillfully craft settlement agreements that ensure the most full and effective relief is provided to those whose rights have been violated. So that, I mean, from an employer's perspective, that sounds like, the settlement offer is going to be on worse terms than what I'm going to have if I lose the trial. Now, I don't know if that was the intent, but that's kind of what the sound of it. So I think you can sort of see where I'm going with this, that, there are strong public policies in favor of settling disputes. One of them being it conserves a lot of resources. And, people have to compromise to be able to settle cases. I think that what we're going to see is in cases where, employers feel passionate about their position, and cases where the NLRB may be trying to expand the scope of the law, not a lot of willingness to settle on terms that don't seem much more favorable than what would occur if you lose the case anyway. I mean, the other problem I think is that the memo also kind of reiterates the general counsel's position that non-admissions clauses should be the exception and shouldn't be routinely granted. I think that's also problematic for a couple of reasons, making settlement all the less likely, particularly if you're stuck in a position of having two-track litigation. If it's a case where you might also have a civil case, then you got to be pretty careful about if you're going to settle without a non-admissions clause. And just in general, there are consequences to settling where you don't have non-admissions. And so it kind of further disincentivizes employers to settle. So I think the concern is it's really just going to lead to a big spike in cases that have to be litigated and can't be resolved. So those were the points that I thought were important to about for today.
Thank you, Bob. That's super interesting. I want to kick one question that I was thinking about as you were talking to Christy, and it's the two-track litigation question. I was just curious in your experience, if you have factual, even now, do you have factual situations where you have statements that are made maybe by employees to each other, which give rise to some question of animus under, the civil rights statutes? Maybe it's in an employee resource group or something like that, where the employer has specifically designated it for conversations about a particular issue, and that those end up as a factual matter in representing protected activity, and also end up representing evidence of animus by the employer.
That's always been common, even well before General Counsel Abruzzo. And I think what the new, if it's new, is that the coordination amongst the EEOC and DOL and just various, even the state, where we would have these concurrent kind of litigation going on based on similar facts. We're just coordinating it a little bit more. But there's been MOUs with the EEOC in the past. And so it's quite common. I mean, I think what we'd like to do in the regions is try to build those relationships with those other agencies even further, so that we can share information, we can coordinate the enforcement, and refer cases to each other, because we see it all the time. And going back to the DEI kind of conversation, I mean, we want to harmonize with the EEOC. We don't want employers especially to prevent or foreclose more active, robust conversations around diversity and equity inclusion, because they're afraid of what might happen on the other end. I would say that's always been protected either way. And where the problem lies is in retaliation. So you'll have a retaliation claim with the EEOC or TFEH, and then you'll have possibly a retaliation claim with us. But it's not the actual, engaging in these conversations. That's the problem. It's just if there's retaliation. So I would say continue to have these conversations. It's really important for society and for the workplace. Going back to the E6 kind of like nexus test, yeah, it's fuzzy, but I think, when I see cases, we do want to see a true nexus. And there's some ongoing litigation, so I can't talk about any case in particular, but I think when we see political activity, there's some that just is not germane to the workplace, or it's not really tied to anything that's really going on in the workplace. And I think, the line is not clear. I think it'll get clear, but definitely there is a line there. And in terms of, well, I think I answered the question. Bob had said a lot of things that just got my mind going as well.
Yeah. It was very thoughtful, Bob. Thank you. And Christy. Tom, Jeremy, do you guys want to weigh in on anything Bob or Christy said?
Well, I know I'm going to have some comments on the PCA side of things, right? So is that coming up?
Now is a good time.
Now is a good time. Yeah, I think that the past administration really tried to chip away at what is protected activity. And I took umbrage with it as a former board agent, honestly, because I looked at these situations such as in Allstate where people were talking about earnings, and it was viewed as griping, which to me is a euphemism for in a collective context of a group complaint. It's the sort of thing that, in my view, would be PCA, and I think that. There was definitely an effort to undermine the set of rights under the Act and to weaken what employees are able to talk about. Whether or not an employer agrees with what they have to say. I think that we're going to go back to a place similar to where we were in the Obama years, where maybe there were some protected activities going on that an employer truly took offense to. Maybe there was some profanity used in the workplace, but it was in the context of a concern expressed about wages, hours, or working conditions, and that's going to be protected. I believe Pier 60 was one of those cases, and I think we're going to get back to a question that's going to need to be reviewed very carefully by employers. Is this insubordination? Is it misconduct, or is it protected? And I remember, many cases over the years where people would walk off the job, an employer would say, "Oh, they quit." No, it's a strike, and or they mouthed off to my supervisor. Well, they did it in a way that related to work. So, we've got to, I think, really do we have an important job to do on the management side in educating our clients on what the law is and what legal protections are. But we're going to see development in that area. There's a comment in Peter Sung-Orr's memo that stuck out to me. It's always been a thought in my head. Employees have as clear a right to organize and select their representatives for lawful purposes as the respondent or an employer has to organize its business and select its own officers and agents. So, I mean, just like an employer hires me to give them counsel, employees have a right to hire somebody to represent them and perhaps advise them on wages, hours, and working conditions. So there's got to be a balance struck in terms of reconciling those rights, and that's citing a Supreme Court ruling, NLRB versus Jones, Laughlin, Steele. And I think understanding that the rights go beyond just having a union, the right to form, join, assist, refrain from, there's a lot more to the Act. So I applaud the General Counsel in recognizing that Section 7 rights go beyond just union issues, that there's got to be some life breathed into Section 7 for it to really fulfill its promise. I think at the same time, I'm concerned, as to, certain employers that I've seen where, maybe their business models at stake, maybe they're relying too heavily on, people they don't consider to be employees. Maybe there's people that, are identified as independent contractors or consider themselves so. They're going to be people who are going to have, I think, rights in the eyes of this general counsel, perhaps as misclassified people or student athletes who it may be unlawful to use that term in terms of a private college or university going forward based upon the general counsel's memo in that regard. And we're going to see some really curious issues brewing as a result of these policies. And I think, in terms of settlement expectations, that Bob touched on, it's going to be harder to settle cases. So I don't know that the settlement rate is going to, be what it's been, because the policies on PCA and expansion of jurisdiction, reaching out to perhaps people considered to be disenfranchised workers, it's going to generate some battles. But those issues are not going to be resolved unless they're tested before the agency and the courts. So going back to something I said earlier, I think it's going to be the businesses that have the resources that are going to fight those battles and carry the water for everybody else, particularly when legislation like the PRO Act doesn't get traction and pass in Congress. So that's what happens when the law doesn't change. You've got regulatory things, you've got changes in administration, changes in policy that are going to play themselves out. And I think, as we've seen through recent administrations, change doesn't always happen right away. It may take a couple of years for the new people at an agency to get their traction. But I'm expecting, we'll see more charges, more trials. We'll see whether the agency wants to stick with Zoom or go back to in-person to achieve these missions. But there's a lot to follow here, and some uncharted territory.
Thank you, Tom. All right, Christy, for our last deep dive, let's try to leave 10 to 15 minutes at the end for questions. Please go forth.
Sure. So I was tasked with talking about immigrant workers, and I think many of these topics that we've covered will dovetail. So, GC 2201 is in everyone's, I think, packets, and that's the memo that I'm going to mostly talk about. But that memo has a previous memo. It's very similar. It's under Obama's general counsel. It's 1503. So it hasn't really changed all that much. I think there's just maybe more examples, and the settlements will be more robust. And so I'll kind of walk you through it. So everyone, I think, knows Shurtan, the Supreme Court case where, doesn't matter what your immigration status is, undocumented workers are statutory employees, and we're going to protect you. So you have protections under the Act, you can come to us. And I think it's a really powerful message, and it's one that we've been trying to do a lot of outreach on, that we want all workers, regardless of your immigration status, to understand you should be able to freely exercise your Section 7 rights, and we'll protect you and to come to us if you've been retaliated against. So I think the questions I generally get then are, how are you protecting these immigrant workers who are the most vulnerable? I mean, there's case law out there saying, if you threaten an immigrant worker with deportation, it's a kind of intense fear that's beyond a regular threat, because it's not just impacting your livelihood, it's your sense of home, maybe separation from family. So once you have a threat based on immigration status, it's really hard to undo. And I mentioned the GC memo on getting injunctive relief on threats. And there is a section in there about threats regarding immigration status. And I haven't seen a case out of my office, but I'm sure there'll be cases where we will likely go for an injunctive relief based on just solely threats. So if you look at the memo, it talks about the different relief that we can give, right? That's not our remedies, but what is it based on kind of our cooperation with other agencies, and those agencies, particularly DHS, they have their own. set of rules. So the first thing is that we're certifying agency for U visas and T visas. Most of the action that we see is U visas. So if you are, helpful to one of our cases, you're part of our investigation, you've been threatened, or there's been witness tampering, you can come to us and we will certify you that you've had a case with us. Right now, under the Biden administration, there's this thing called a bona fide process. So basically, even if you don't get your U visa during the time period that your case is pending, you can get deferred action and you can get a work authorization for you and your family. So it's a really powerful tool to ensure that employees can come to us. And the U visas are capped at 10,000 a year. And there's a huge backlog, like a 5-year backlog. So this bona fide process under the Biden administration is pretty important, because while you're waiting that 5 years, you can get deferred action. The other things that we've done in the past is get parole. And I'm not an immigration attorney, so I'm not going to talk too much about it, but it's DHS using their discretion to allow someone to enter and stay in the country while application is pending. So we have a lot of cases, and I can go through some examples, but in the interest of time, I'll just kind of go through. The memo also has some safeguards about the investigation phase. Our orders are to tell everybody who comes to us, your immigration status is irrelevant and we want our board agents to be able to tell this to the witnesses that come forward, to the charging parties that come forward. If coming to the federal building is an issue, we tell our board agents, go find a safer place, a place that everyone's comfortable meeting. Aliases can be okay, different addresses can be okay. Just we're trying to create a sense of there's no barriers. Don't be fearful in coming to us, the government, because a lot of people who are, it's not a status issue either. It's just if you come from a country that had a lot of abuses by the government, people are fearful in coming to us. So it's just one way to ensure that everyone, all workers are comfortable coming to the NLRB. During the ULP hearings, we have various safeguards as well. If questions are asked about status and it's irrelevant, of course, objecting to those questions, but we don't want those questions to happen in the first place. So there's motions in limines. We'll try to quash a petition, or a subpoena. We'll file motions for bill of particulars. And we have instances where we do refer misconduct charges to the board and to the state bar if we feel like an attorney is engaging in these practices, just with the intent to interfere with an organizing campaign, for instance. And I wanted to briefly talk about remedies, because it kind of dovetails into the discussion we've already had. So consequential damages, we're kind of seeking it everywhere, but it's really important. If someone actually doesn't have status, you can't get them reinstated, and they can't have back pay, right? So you can only get pay for work that's already happened, but you can get consequential damages. You can maybe get instatement of other people for their position that would kind of play the same role in the organizing campaign. Maybe there could be a monetary fund set up that could inure to the benefit of the entire unit. There's training, notice reading. But I think still the most powerful thing is if we collaborate with DHS and get someone deferred action or parole. We have a lot of interagency engagement, and the memo talks about that as well. I think one of the more important ones the memo talks about is this notion of deconflict. So there's MOUs with DHS. We're trying to prevent conflicting enforcement actions. So ICE will refrain from coming to the work site or doing, having their own enforcement action if they know that an NLRB case is active there, if there's an active dispute there. So that's kind of an ongoing relationship between the agencies. And I think the memos kind of speak for themselves. If there's any questions, I could answer those, and I'll stop there.
Just have one quick question for you, Christy.
Mhm.
You mentioned it briefly, which was the instatement of a qualified candidate
Mhm.
referred by a labor organization. If you could just talk quickly about if there's the history of that, if you know it or feel able to speak about it.
Yeah, I can speak about it. I mean, to the extent that, we're tasked with thinking about how to creatively put back something, to where it was prior to the ULP. And it's a very hard thing in an organizing campaign if a group of employees will no longer engage in Section 7 activity because they're fearful. And if they're not there at the workplace, you've lost the main organizer maybe. So I think the idea is if that person can't get back, you find someone else that would be similarly play that role, the eyes and ears of the union, for instance, if it's the institutional union heading up the campaign. I haven't seen it happen in a case, but I've seen us think about it, and I've seen it in the memos. So I think because this is really rare. In most instances, if there's reinstatement, we are reinstating that very person who's been discharged. So these remedies are all out there, but for the most part, 99%, we are getting the person who was fired back into the workplace. I think the monetary fund is an interesting idea, and we do it for other 8A5 cases, bargaining cases where the damages to the entire unit, and you can't really parse it out. Is one person should receive this amount versus another person? It goes into a fund, so that's not too out of the box. But the idea is the employer should be able to, they have to pay somewhere. If they're not, if the money's not going to that particular worker, it should go to a fund that is to the benefit of the organizing employees. I think in terms of the letter, the union access, training, all that. I mean, everything is supposed to also have language access built in. So we're doing, we've been moving toward having more of our materials translated to various languages. We do that for notices, but right now, we have the Spanish language website and Twitter and various things. But our goal again is to make it as accessible as possible. So if you have a case with us and there are groups of employees who speak one language or another language, just always mention it to us so we can get all our materials translated. It's very important to us that it really reaches everybody. And we won't know that. We'll only know that if someone tells us. So I think if you look at the portion of this memo with remedies, it dovetails with the other memos regarding remedies and settlements. And so again, going back to this kind of holistic look where everything's kind of moving toward a certain direction.
Thank you, Christy. Other panelists, any thoughts on that? I thought in-statement again was particularly interesting. I don't know if, Jeremy, have you ever asked for in-statement before?
No, and I certainly will. I think it's a very creative and a very good idea. I mean, we come across workers who, are not authorized, and it's incredibly frustrating. Los Angeles alone has, more than 1 million undocumented people, and they're concentrated in the low wage sectors where, organizing is most important and most needed to, eradicate labor abuses and wage theft and that sort of thing. So for there not to be any remedy for those workers is a huge policy failure. And I really applaud the board for thinking creatively about how to find ways to make some meaningful change or some meaningful remedy in those situations. And, it certainly recognizes the board's policy of, it's not about just protecting that one individual, although that's crucially important, but the organizing efforts of the workers at large and avoiding the chilling effect. And, the point about eyes and ears that Christy just made, that's all just incredibly real. You decapitate the lead worker of an organizing campaign, the thing ends, everybody's going to be terrified. So I think it's great. I'm looking forward to, well, in some ways, I guess I'm not looking forward to facing the situation where if we confront that, but if we do, I greatly appreciate that, that's something that's on the table. And I think it does relate to sort of this question about settlement that came up earlier as well. I mean, these things will probably need to be litigated, but they should be. You know, the existing remedies are so weak now that the settlements just frankly aren't worth much. You know, most employers will settle out in 8A1 easily as soon as the complaint's authorized. But there's just not much meaningful consequence on the, you know, in the real world. So, you know, if it requires the board to take these cases to trial, so be it, because, you know, that's what it will mean. You know, I certainly appreciate the budgetary constraints, but you know, the work needs to be done. If there's no private right of action, we depend on the government to do this work, and I think we should you know, support them in doing that work and push for their funding.
Thanks, Jeremy. Tom, Bob, any thoughts on remedies for undocumented workers in particular, the Hoffman Plastics issue, in statement, creative remedies?
I actually was at Region 21 when Hoffman Plastics was pending and under investigation. And so that case always, you know, sticks in the back of my mind as just, you know, something that is, I'm not going to opine on Hoffman Plastics, but it's certainly an issue that has stuck in the board's craw for many years. As a Spanish speaker, I came to California because I speak Spanish to work for Region 21. And I remember so many situations where people were petrified and they wanted to, you know, maybe tell me, you know, I'm not legal. I don't have my papers, whatever it might be. And sometimes they would disappear because they were afraid to follow through with the charge that they had filed or that they were named as a discrimination victim. And I think that's been a really big gap in the agency's ability to enforce the law and to provide meaningful remedies. As a management lawyer, certainly I want my clients to comply with the immigration laws and employ people who are authorized to be in the United States. But if you're going to have a system of law that provides equal rights to everyone under the labor laws, you need to, you know, reconcile with this area. So I commend the General Counsel for looking at this. I think it is going to be litigated. There are going to be people who are going to want to challenge this, but I think that if you're going to get people to come to the agency and to bring the issues that they have to feel protected to do that. And they have to be aware of their rights. So I think it's good that they are made aware, and they need to feel comfortable talking about what happened to them, because these are real world issues, and they're happening in workplaces across our country. We happen to live in a place where we see more of these things than other people do. So I don't take issue with this. I think it is something that needs to be addressed.
Bob, any thoughts from you?
Well, yeah, I agree. I mean, it's people are being exploited, and it's always going to be a challenge to vindicate that. But I mean, no employer should be in a position to be able to benefit from employing undocumented workers, and in particular in ways that are compliant with the laws that apply to everybody else. So.
All right.
May I ask a question while you guys are all here? So part of the settlement.
Yes, but wait, I want to kick it to the audience.
Mm-hmm.
I want to hear your question, but I want to kick it to the audience too. Is that okay, Christy? Or do you want to?
Yeah. I just wanted to survey something.
Oh, do your survey. Go ahead.
Just, do you find the trainings like worthwhile when we're ordering trainings? Trainings for managers, training for workers. We're doing that more and more.
I haven't really seen it from my point of view, but I'd really welcome it and like to see how it plays out. It certainly seems worthwhile.
I've had a couple clients do it, and they've appreciated it.
All right, going to questions from the audience. If you chat at me directly, I'll read it anonymously. Here's one question, and I won't call on any of you. If any of you feels inspired, please talk. If you talk all at once, I'll segregate. On card checks, given the past practice and proposed action, any thoughts on outcomes or changes? And I think this sort of relates to another one. When is the whiplash going to end? Is it ever going to end? What do employers do about it? What do unions do about it? please weigh in. All right, I'll call on you, Jeremy. You're first.
The whiplash, I mean, I think there's two sort of like frames I would bring to that question. On the one hand, it certainly is a sense of whiplash. And, you know, the last thing former general counsel was doing before his tenure ended was seeking to outlaw card checks, and, you know, which is the primary means by which most private sector workers now organize. So he would have, you know, had his theory gone forward, would have essentially made illegal most union organizing today. I mean, that was pretty extreme. I don't, you know, certainly the new general counsel has gone in a different direction. I don't believe the kinds of things the new general counsel or current general counsel is pursuing are, you know, anywhere near as extreme as that was. Frankly, I think they're, you know, obviously things that many employers are going to oppose, but they're not nearly as extreme as you know, trying to bar, you know, card check neutrality agreements. The other window I would have on it is just, you know, so much of labor laws, I think was sort of referenced earlier, and the reason why it's been seen as sort of not cool is because it's been largely irrelevant to most workers' lives. And so, you know, I think a shift is long overdue, and most, you know, I think most people in this country would appreciate the efforts that are now underway. And I think they're much more in the mainstream than sort of the, you know, the opposite end of the spectrum. What was it? Is that, I don't know if that addresses the question.
That's good. Tom, Bob, thoughts on advising with, in spite of the whiplash, dealing with it, relating to card checks a little bit, advice on how to deal with it, how you're dealing.
You know, I think it really depends on the circumstances when it comes to a card check. It's hard to really you know, say a general point other than, you know, you sort of have to know what's going on in your workplace, and I'm not going to, you know, bless them categorically or condemn them categorically. It really depends on what's going on, and I don't think they're, you know, a complete substitute for elections, for example. But I'm not sure what else to say about it at this time. But what other questions did you have, Josh?
Those were there's where we're at so far. Bob, any other thoughts on the, you know, dealing with the transition between the administrations and how you're counseling, and in particular how card checks may come into play and dealing with the pivot there?
You know, I think there's probably less whiplash than we talk about. You know, if you're measuring it by a GC council memo, you know, maybe more than what you're actually seeing if you're looking at what the board's actually ruling. There are obviously some issues where the law is going back and forth, and so, you know, you need to decide if you're an employer how aggressive you want to be, and, you know, there's obviously risk that the pendulum will swing back. So is it worth the risk to take a more aggressive position? You know, on card counts, I guess I'm with Tom on this. It's hard to give just a generalized answer on card counts. I mean, we do them with some of our unions at Kaiser. You know, so I think there's certainly a place for them. But you know, I think it's probably case to case, employer, situation to situation.
All right, we've only got a few minutes left, and I want to do a tiny bit of housekeeping before we close. Christy, I will give you the last word as the institutional perspective on the whiplash, talking to shocked management lawyers, shocked union lawyers, and your advice to them, and, you know, how they're dealing with their respective clients and whatnot.
Ooh, advice. I you know, I've lived and worked through a lot of administrations, and I want to say that the center of what we do, kind of the central part of the act, it's not changing, and it's just a lot of things on the margins that go back and forth, except for maybe the work rules. I do feel a little bit bad about that, But, you know, I would say, you know, if under our current statutory regulatory scheme, yeah, we're going to keep having that. So if Congress changes the law, yeah, we might not be in this boat. But I would say that if I'll just leave it at that. There is some level of it, but I think by and large, you know, we're not going to change in terms of don't fire people for engaging in protected activity. And, you know, there's a lot of bread and butter things of the act that's not changing.
All right. Thank you for letting me pose multiple unfair questions to you, Christy. I want to thank our panelists so much. I personally would listen to you guys for another 2 hours, but we promised we would end it at 6. So I want to be respectful of people's schedules. Everyone for MCLE credit, please put your state bar number and your name in the chat. Before you go, we will then email you an MCLE certificate. So thank you so much again to our panelists. I know you can't see everyone clapping, but I'm clapping on behalf of the audience. That was really, really wonderful. Thank you so much, Christy and Bob and Tom and Jeremy. I learned so much listening to you all. And then to the audience, I'd say don't forget our summer labor law conference, which will be in July. And we look forward to seeing all of you there. And so I'm going to stay on now just to ensure that everything goes smoothly, but everyone can leave once they've added their information and their state bar number. And thank you again, everyone, for attending. All right.
Thank you.
Thank you.
Thanks, everyone.
Well done, everybody. Please, you know, I would ask the people that are still staying on to put your comments and thanks in the chat, because it's surprising to me on these virtual programs, the panel just kind of gets let go and nobody really says anything. So it really goes a long way. But thank you, everybody. Fantastic job, panel. Loved it.
Yeah, and don't positive and negative. We like all of it. Just like we like to see both sides of an issue. We like to hear what you guys want us to do better. So don't be shy.
Great.
Just to plug, if any organization out there wants, you know, training from the NLRB, every regional office is willing to do it. You can even contact me and I'll get you to the right office. So don't be shy. We're happy to do it.
Thank you. And just a quick plug, if you know somebody that didn't have a chance to see the program, it will be uploaded for our members only for SoCal LERA. And please join the organization and join the community. Thank you. And really great job, panel. Christy, you're wonderful. Bob and Tom and Jeremy, fantastic. And Josh, great way to work through the program. Thank you.